Today we're going to look into all the latest judgments from the Honorable Supreme Court of India, the NCLAT and the NCLT, and over to Anil sir for an hour long of updation on what is going on with respect to jurisprudence on IBC.
Thank you, Ankit. I welcome all the participants to our 78th episode of AAA Weekly Webinar Series. This episode I am conducting from outside India. I was traveling for work as well as for some vacations. So I'm conducting this from outside India. So the latest judgments are important, and I would say that the law is actually getting settled, and the time has come when the litigation will actually be much reduced, because the time and again when Supreme Court gives almost 7-8 judgments in a month on IBC, that actually would mean that most of the issues would get settled, and then all the stakeholders would not like to prefer appeals where the issues are settled. So today we are deliberating on 7 Supreme Court judgments, and if the time permit, we also have analyzed 3 NCLAT judgments and 3 High Court judgments. It all depends upon the time that we try, and we would welcome the questions also, Ankit. So the judgments, like in case we try to see, the judgments are primarily, one is on the consolidation of CIRP processes between the holding company and the subsidiary company. Then whether the electric connection would be given to the successful resolution applicant while the dues of the electricity supply company is pending. Then, of course, the limitation law is getting strengthened and strengthened over a period of time. There have been many judgments. There is another judgment on Section 18 of Limitation Act. Then power to recall its own judgments by NCLAT is also something which is very clear from Supreme Court. See, the claims which are coming again and again after the resolution plan is approved by the Committee of Creditors, that issue is getting settled. So most of the litigations are on the claims. One, that the IBBI has pronounced the regulations where the RP will admit the claim up to the date of release of RFRP as per Regulation 36. And then again, one application will be filed by the RP where all the claims would be addressed along with the opinion of COC and along with the RP's opinion. So therefore, and that particular application will be submitted 1 week before the COC approves the resolution plan. Now, however, after the resolution plan is approved, I don't think there will be any kind of litigation on the claims. So that's another judgment that we are going to discuss today. Then the one very, very important judgment is that the most of the time that we have seen that liquidator tries to take the power that I can cancel the auction process. Reasons can be many. The reasons can be the stakeholders are saying that this is a low value and the value can be increased, or even there can be some hidden agenda also with some of the liquidators, that they keep the power that even if the process is conducted rightly, they can still cancel the auction. That has been checked by Supreme Court, that the liquidator has no power to cancel an auction which is conducted lawfully. Then, of course, the claim of the Custom Department would not override the claim of the secured creditors. These are the Supreme Court judgments. So, Ankit, I would share by PPT, maybe that some of the parts we would quickly run through, because I would like to cover more and more judgments. So first we will cover the Supreme Court judgments, and the first judgment is Region Power Tech Private Limited versus Giriraj Enterprise and others. And this is a very, very latest judgment in 2023. And this is where the one issue the Supreme Court has said that the resolution professional should remain neutral. The resolution professional should not file appeals against the orders of adjudicating authority or appellate authority in case the resolution professional is not aggrieved. Only the aggrieved parties should file the appeal. So in this particular case, there were two companies, CIRP of two companies started. One was the holding company, the other was a subsidiary company. And in this case, the principle of equity was also discussed, whether the principle of equity is within the jurisdiction of NCLT or not. So let us see the facts of this case. One is let us take the short names. RPPL is the holding company and RISPL is the subsidiary companies, and they are in the business of, one is the holding company is in the business of manufacturing of wind turbines, and the subsidiary company is in the business of operations and management of the wind turbines. It is very common that manufacturing and installation is one part of this wind turbine business, and the operations and maintenance is another part of the wind turbine business. If the manufacturer is not supporting the subsidiary company, it is very difficult for the subsidiary company to continue in the business, because in the operations and management, most of the technology, most of the components will come from the manufacturing company. So the manufacturing company and the holding company is considered to be something which is almost collaborating with each other to do one business. Now, the holding company was admitted to CIRP in December 2019, and the subsidiary company was admitted to CIRP in February 20. Independent resolution plans were received in both the companies. One resolution plan was approved and the other was still pending. So while the other was pending, this particular case was, in fact, this Region Power Tech Private Limited is the operational creditor. Operational creditors filed the application under Section 9, and now at this moment, when the resolution process already have gone through about 18-19 months, at this moment, the operational creditor again files an application saying that the CIRP of these two companies should be collabed together. It should be considered as a group insolvency, and the resolution should be sought for both the companies together. Otherwise, the businesses will fail, and this is not appropriate that the resolution for each company goes to different companies. That was the application made by the operational creditor. Now, what happened before the appellate authority? The operational creditor says that I have entered into an operations and management agreement with the subsidiary company. My business will fail in case there are two successful resolution applicants, one for the holding company, one for the subsidiary company. And he also argued that the adjudicating authority have sweeping powers under Section 65 of the Code to adjudicate all situations arising out in relation to CIRP. And he also said that the adjudicating authority erred in concluding that the consolidation can be done only in exercising the equity jurisdiction, which the adjudicating authority doesn't have. So in this case, the appellant says that the consolidation was necessary to retain the commercial viability and maximization of the value of the asset. So therefore, he said that the adjudicating authority has erred in rejecting his application. No, the respondent means the RP of the holding company. So there is also some issue that if the RP of the holding company and the RP of the subsidiary company are different, then I think the RP also would have some vested interest that these consolidation, if the consolidation would be done, which RP will continue and which RP will not continue. I think that was also a little bit of issue in this case. So RP of the holding company submitted that these appeals by the operational creditors are infructuous and it is belated and the resolution plans have been approved. So in case the group insolvency was supposed to be applied, it should have been applied on the beginning of the CIRP. Now it is 18 months over where the CIRP is continuing. And also the operational creditor doesn't have any locus, so it can be even the application by the creditor, but the operational creditor has got no locus. So therefore, the application should be rejected. So what NCLAT said, NCLAT in fact allowed the consolidation, relied on the report of a mediator that unanimity, the resolution plan must be one for both the companies and the efforts must be made to identify a single purchaser. The report states that the joint sale of both the companies is possible and this would result in the value maximization. Now, in this case, when we go to the history of the group insolvency, in fact, it started in the case of State Bank of India versus Videocon India Limited. That was decided in 2019 and it was decided by NCLT Mumbai and it was confirmed by NCLAT later on. So in that particular judgment, some of the parameters was discussed, that under what are the parameters and when we can actually take a decision of group insolvency. So these were, you can see on my slide, the parameters which was originally held in the case of State Bank of India versus Videocon, and later on it was confirmed by NCLAT, and even after that it was further confirmed by Radico Khaitan Limited versus BT and FC Private Limited. That was done in 2021. And further, it was also confirmed by NCLAT in the case of OSC Axis Pacific Pte Limited versus Axis Bank. So this particular process of identifying whether this group insolvency is required or not, these are the parameters which has to be seen by the adjudicating authority. If there is a common control, common directors, common assets, common liabilities, interdependence of business is very important. And interfacing of finance, interlacing of finance, pooling of resources, coexistence for survival. Now, in this particular case, the existence of subsidiary company will depend upon the manufacturing company, which is in the business of manufacturing and installation of wind turbines. So this particular case, it was applicable that the Videocon and the OSC and the Radico Khaitan was applicable in this case. Coexistence of the intricate link of subsidiary, intertwined accounts, interlooping of debt, singleness of economic units, common financial creditors, common group of corporate debtors. So these are all the parameters, and therefore the NCLT held that the holding company and the subsidiary company had interconnected business relationship in terms of providing the operations and maintenance services to the customer. Hence, the subsidiary company was dependent only on the holding company. This is what I've been saying. The consolidation of the CIRP cannot be construed as an equity jurisdiction, because see, it has been held in many cases that the equity jurisdiction is not with the NCLT, because in IBC there are many decisions which are taken, which is process-based, procedure-based, administrative decisions, just to implement the IBC. And it has been seen that in case the equity would be seen, then the operational creditors are not being given. Then in some of the cases, even the similarly ranked creditors are also not being given similar amounts. So the equity jurisdiction is not supposed to be with the NCLT. However, in this particular case, the legal principle is the intention of maximizing the value of the assets and the maximization for the recovery from the resolution. So therefore, uh, holding and subsidiary company would regard it as single unit owing to the nature of business. So however, the after the NCLAT order, it went to the Supreme Court, and the Supreme Court held that while adjudicating an appeal preferred by the RP before the apex court, challenging the decision made by the NCLAT, the observed that the RP do not have the authority to file appeals. The RP should have maintained a neutral stand. It is for the aggrieved parties, including the Committee of Creditors of Region Power Tech Private Limited and Region Infrastructure and Services Private Limited, to take appropriate proceedings or file an appeal before this court. Only parties directly affected, such as Committee of Creditors, were entitled to file such appeals. No, I think the RP should not have filed this appeal. RP should not bother whether he is continuing as RP or the other RP is continuing. The RP, the RP is a professional. In case he will be doing the work, he will get the fees. And in case he will not be doing the work, he will not get the fees because he will get another case. So what I understand is that in this particular case, even it was permitted to the Committee of Creditors to file another appeal in case they are interested, in case they are feeling aggrieved. But what the RPs should consider is that the RPs only should file appeals where they are aggrieved. In case the RP is not aggrieved, the RP should not file an appeal. So, however, in this case, the two things that we want to say: one, that the consolidation of the CIRP into one CIRP, considering these two businesses as single unit, that is the jurisdiction of NCLT, and there are parameters. Those parameters are confirmed. The Supreme Court has not commented on it because the Supreme Court will actually comment on when the appeal will be filed by any members of the COC who would be aggrieved out of this decision. RP cannot be considered as aggrieved because one RP is not now the RP because of the consolidation, the other RP is getting the business. That kind of appeals are not supposed to be filed. However, the meaning of this judgment should not be taken as if the RP will never file an appeal. If the RP is aggrieved, the RP can file an appeal. So, Ankit, anything that comes from you in this?
I have a different take on this whole judgment, and I think that if there was a resolution plan that was passed already for one company, and the NCLAT kind of said that no, at a later stage, much later stage, and that too on the application of an OC, you merge the two processes, and then subsequently, my understanding is that if resolution professional is not the guardian of the CIP process, or rather the responsible person for the CIP process, then who is? Because in case you start opening the Pandora's box that okay, RP is aggrieved or not, then there will be applications filed by many other entities. Now the COC is only representing their own interest, that is the financial creditor interest. There again, the COC can decide to do something or not to do something based on their individual voting shares. The majority or the minority bankers can then again, if they're aggrieved due to some decision, can go to the process. But the RP is responsible to take care of all the creditors and make sure that the process is followed. Now, in this case, in case the process was followed and the process yielded a resolution plan, which was then approved, and at a later stage, the resolution plan was challenged and rather it was reversed through a merging of the two cases at NCLAT level. I believe the CRP process was in a dilemma because of that NCLAT judgment, for which maybe RP was responsible to take care of the CRP process, or maybe he was not. But then, what I'm trying to say is that would can we say that the COC is the aggrieved party if the RP or the CRP process itself was not also the RP is representing the company. The company does not have any head when the CIRP process is going on. So any problem, any issues that the company is facing during insolvency or during CIRP, that should also ideally, be the RP's job.
So I think the value maximization is the duty of the RP. If the NCLAT says that the consolidation of the CIRP processes would actually enhance the value, then how the RP is aggrieved, that is what is the issue before the Supreme Court. And the Supreme Court decided that the RP is not aggrieved, so the RP should not have filed the application, filed the appeal. Now, I think as far as this, our job is to analyze this judgment and also guide our participants that the RP can file an appeal in case the RP is aggrieved. And in case RP is not aggrieved, then the committee of creditors can file the appeals. But in case anything which is incorrect in the process, anything which is non-compliant to the process, any judgment which the RP feels is non-compliant, the RP can still file an appeal. This is what I think. RP, as Ankit is saying, the RP is also, RP's duty is to see that the process is being conducted as per IBC and the regulation made thereunder. Going to the next judgment, it is a Tata Power Western Odisha Distribution Limited and others versus Jagannath Sponge Private Limited. In this case, the successful resolution applicant filed this application. No, issue is whether the in Tata Power, which is the electricity distribution company, whether the electricity distribution company had the legal right to insist on the payment of the arrears, and those arrears belongs to a period prior to initiation of CIRP, and now the resolution plan has been approved, and the new resolution applicant has actually taken over. No, the electricity department had some dues of about 13 crores in 2015, and in 2019 the CIRP started and the resolution plan was approved, and then the successful resolution applicant in August 22 made an application for giving an electric connection. Of course, the same supply company and the electricity supply company asked for that 13 crores of the outstanding amount. Then the adjudicating authority, first application was filed to adjudicating authority, and it was directed by the adjudicating authority to the electricity company to the demand is not to be pressed and the electricity connection should be given. And then the resolution plan is binding, so therefore arrears were not valid. So then the adjudicating authority also noted that the appellant had not filed any claim, and then in that case the appellant contention was that the electricity dues were due and payable. So these are all like very, very. But then let us see what finally happens, because you see, even ANCLAT also upheld that the electricity department, electricity supply company have no right to claim the dues, and in case this is allowed, then but then Supreme Court's observations are very important. The Supreme Court says that this Tata Power cannot insist on payment of arrears, which was required to be paid as per the waterfall mechanism for grant of an electricity connection. While the successful resolution applicant was required to comply with the other requirements for grant of electricity connection, the clean slate principle would stand negated if the successful resolution applicant was asked to pay the arrears payable prior to the initiation of CIRP if the claim pertaining to the said had not been filed. Now, it was also held that the issue of court, because see, it was raised from the respondent side that this issue, whether the successful resolution applicant can file an application to adjudicating authority and then to appellate authority and then to Supreme Court under section 65. The Supreme Court said, yes, this is an issue arising out of or in relation to insolvency resolution. So therefore, the successful resolution applicant has the jurisdiction to file this application and then appeal. So finally, the Supreme Court said that this judgment of NCLAT is right, and it cannot be, the Tata Power cannot ask for the arrears. So this is, I think, in a couple of other judgments also, we have seen that it has been held, but most of the distribution companies or power supply companies are insisting for this issue. But now, since we have 2-3 judgments, this issue would be considered as settled, and most of the distribution companies would not waste time and would not go for litigation once the Supreme Court has decided multiple times. Coming to the next judgment, it is Axis Bank Limited versus Mr. Narayan Sheth, RP of Shreem Corporation. Now, this particular case is regarding limitation. In this case, it's a limitation issue, and Section 18 of the Limitation Act is the applicable here. Now, what are the Section 18? Of course, I'm not reading Section 18. In this case, the SBI, in fact, declared the company as NPA on 28th of June 2013. Now, the NPA date is normally 90 days from the date of default. So therefore, the date of default in this case is considered to be the end of the 31st March 2013 financial year. So therefore, the court says that it is the limitation period is actually, the appeal could have been filed up to 31st March 2016, whereas the appeal was filed much later. Now, in this case, there are 4 major acknowledgements made by the corporate debtor after the account was declared NPA. First of all, the balance sheet of 14-15, this particular loan of State Bank of India was shown, and this is also considered as a balance sheet acknowledgement of the debt. So therefore, from 31st March 2015, 3 years was reckoned, and the limitation period got extended to 31st March 2018. Then subsequently, before even the next limitation period, which is ending on 31st of March 2018, there was a one-time settlement proposal submitted that was on 16th of March 2017. So therefore, the period again gets extended from 16th March 2017 to 3 years, because this is a written acknowledgement as per Section 18, written acknowledgement VAT, because the one-time settlement proposal is also considered to be a written acknowledgement. Now, the second OTS proposal was dated 1st of January, and the third OTS proposal was 16th of May 2019. So therefore, the limitation period gets extended from 16th May 2019 for another 3 years, and the application was filed in 2020. Therefore, the application was well within the limitations, and also when the application was filed, there was another application under Limitation Act for condoning the delay that was also filed along with the application. So the adjudicating authority condoned the delay, and the application was admitted. And then like this is the first appeal was filed before ANCLAT, and that was dismissed. And against the ANCLAT order, the case went to the Supreme Court. Now, the Supreme Court held as under Section 3, subsection 1 of the Limitation Act creates a bar for institution of any suit and application made after the prescribed period of limitation to be dismissed, even though limitation has not been set up as a defense. Now, what actually this means is that even if the respondents are not taking this limitation as an argument, the act is applicable. Even if it is not shown as a defense by the respondents, the court has to see whether this particular application is admissible or not. Section 5 of the Limitation Act provides for an extension for the prescribed period in certain cases where sufficient cause for not preferring the appeal or where the application could not be made within the prescribed time. Section 18 of the Limitation Act provides that where acknowledgement in writing of the liability is made by a party against whom any right is claimed, a fresh period of limitation can be computed from the time when the acknowledgement is so signed. So Section 5 is basically providing for an extension that where a condonation application is filed already in this case. And Section 18 talks about the acknowledgement in acknowledgement in writing. So therefore, the fresh period of limitation would be granted. The plain reading of Section 18(1) of the Limitation Act would reflect that where any acknowledgement of the liability has been made in writing by the party against whom any right is claimed, a fresh period of limitation would be computed from the time when the acknowledgement was so signed, subject to such acknowledgement being made before the expiry of the prescribed period for filing a suit or application. Now, coming to the 18 subsection 2 of the limitation may not be applicable in the present case since all the acknowledgement in the present case have a date, and therefore there would be no question of needing any oral evidence to establish the date of the acknowledgement. Now, in this case, there was a tendency that the banks used to take a blank letter of acknowledgement. And there was a section like 18 subsection 2 of the Limitation Act that was talking about the oral evidences in case the blank date is in case there is no date mentioned on the limitation. Now coming to the finally the Supreme Court said that the document relating to finally the Supreme Court said the document relating to the acknowledgement claiming benefit of Section 18 were introduced at appellate stage, and such document being balance sheet and settlement offers, it was held that same could be accepted even at appellate stage, and a settlement offer akin to an OTS proposal would be an acknowledgement of debt for the purpose of Section 18 of the Limitation Act. A balance sheet acknowledgement debt is also a document relevant for calculating the limitation. The acknowledgement should be made within expiry of the limitation provided under the law. On this point, it has been factually found that taking the date of the acknowledgement of debt in balance sheet and 3 OTS proposals, the same were within the limitation under law or extended limitation due to the acknowledgement. So therefore, this particular case was admitted to the NCLT. So Ankit, so two things that one is the electric connection case and the other is the limitation. So would you like to add anything before I move on to the fourth judgment?
And I believe we should proceed. We have some questions. I can try and ask some questions that are relevant. So one question is that can the continuing charge in favor of FC be considered as acknowledgement? That's from Mr. Pankaj.
Continuing the charge which is registered.
Continuing charge. So there is a charge which is registered in MCA with respect to the with respect to the CD from the financial creditor. So the charge continues is registered and it continues to be registered. Then
that is not considered to be an acknowledgement because the charge was registered like in this particular case. For example, the charge was registered in 2015 and there is no further modification or there is no change. So that will not be considered as a valid acknowledgement of debt because that document was submitted in 2015 and the application cannot be filed in 22 based on that charge because there has not been any modification since 2015 in that charge. So continuation of charge before the registrar of companies or MCA website, that would not be considered as the acknowledgement of debt. Yes, Ankit.
Then we have a question that in case a default occurs in 2018 and the application is filed before NCLT but was withdrawn due to settlement, Since the settlement failed in April 2020, another application was filed, in this case covered by Section 10A, since the second default occurred in after March 2020. So limitation is what the question is, that will this be
No,
limited?
it
So with
actually
the
depends.
so basically here, my understanding is that if the settlement had happened in 2018 and the settlement's terms have been violated, then the limitation would continue. Limitation would not cease because you have a settlement agreement in 2018 acknowledging the debt, and then you have a default again in March 2020.
No, you are absolutely right. When a settlement took place, in that settlement, definitely there would be some acknowledgement of debt. So that acknowledgement of debt will also
But it
the
depends on the
restart
wordings
the
of the
limit.
settlement. Yeah, if the settlement has not acknowledged the debt, then that's the problem. Yeah. Normally, a
No,
settlement would be like.
in case you see, like there are two scenarios, Ankit. One, that the application is simply withdrawn without mentioning any reason because there is some settlement. Second, if there is no document made for the settlement. So in these two things, I don't think there will be any kind of debt acknowledgement, or there would be any extension of the limitation period. However, in case there is any reply filed by the respondent, or in case there is anything mentioned in the settlement agreement, then it will be considered as renewal of the documentation and acknowledgement of the debt.
So the coverage of the coverage of the second case by Section 10A will depend on the nature of the settlement, right?
Yeah, see, like that is also a judgment which is coming. I'm actually coming to another judgment, which
So we will
also
talk
says that,
about
also
this
talks
when
about
you
that.
come to that
Talks about
judgment there.
yes, yes.
So yeah, let's continue.
So the fourth judgment that we are talking about today is Union Bank of India versus financial creditors of Mrs. Amtech Auto Limited. Now, the basically the judgment is regarding the power to recall and review its own judgment. What is the power of appellate authority and CLAT? Now, it is a NCLT Chandigarh case. The resolution plan for the corporate debtor was approved in July 2018, and the Union Bank of India was a dissenting creditor. An application under Section 60, subsection 5, clause C, seeking directions for modification of approved resolution plan in compliance with Regulation 42 and 44 of the Liquidation Process Regulations. The dissenting creditor filed an application against reduction of 30 crore from the final payment. So, see, Ankit, in this case, it happens like this Union Bank of India had kind of issued some letter of credits, bills drawn by the vendors of the corporate debtor under letter of credit. Bills drawn by the vendors of the corporate debtor under letter of credit established by the applicant were paid to vendors who are ultimate beneficiaries. Now, this is a case where uh, some of the LCs were also discounted by Union Bank of India, and the vendors were the beneficiaries. So Union Bank of India somehow got that money from the issuers of letter of credit, and the COC decided that that particular amount, which is 34 crores, will be reduced from their allocation of fund, because see, the Union Bank was the dissenting creditor. So this was a dispute of 34 crores. So this was the contention of the applicant was that this money should not have been reduced from their entitlement. So the NCLT Chandigarh says that the NCLT, taking into consideration the contentions raised by the RP, approved the resolution plan and rejected the application, to which an appeal was preferred before the appellate tribunal. And the appellate tribunal, what was the proceeding before the appellate tribunal? So it is pertinent to state that the resolution professional had stated before appellate tribunal that the letter of credits issued were illegal recovery made by the appellant. The RP therefore submitted that the COC had the option to either treat the same as interim finance or deduct the same. Now, this appellate tribunal held the definition of interim finance was also seen. The definition of CIRP cost is also seen. So the this is, as far as this dispute is concerned, uh, I think it was not very clear from the judgment what was the dispute regarding the letter of credit, whether any additional finance was given by the Union Bank of India. And it was, if it was an additional finance given by the Union of India, then like definitely they would have filed their claims of non-fund based facilities which were outstanding. Because see, whenever there are letter of credits outstanding, the banks are permitted to file their claim for non-fund based facilities. Some error has taken place in this case. I am not going ahead. Therefore, I am not going to the facts of this case. I'm only coming to the process where the NCLAT wanted to recall its own judgment. So the the judgment was passed by NCLAT, and then the Union Bank of India preferred an application to the NCLAT, submitting that the resolution plan was approved by the COC and the adjudicating authority has been modified by the appellate tribunal without hearing the COC, which was necessary party to the appeal. The NCLAT, after considering the circumstances, observed that the recall can be asked only as a procedural infirmity, like orders passed without necessary party service to the necessary party or affected party not being heard by the court. Further, this matter was referred to the larger bench, and the larger bench also laid down that the distinction between recall and review. The power to review is not conferred upon this tribunal, but the power to recall a judgment is inherent in this tribunal. Now, there is a difference between the review and the recall. Recall is possible, review is not possible. In the recall, once the judgment is made where the total procedure was complied with, when everyone was heard, then only the appeal is possible, and that is, review is not possible. However, recall is possible when there is a procedural error committed in delivering the judgment. For example, necessary party has not been served, or necessary party have not been before the tribunal when the judgment was delivered adverse to that party. No, the larger bench judgment, where the distinction was made between the recall and review, this was upheld by the Supreme Court in this case, which is this Union Bank of India versus financial creditors of MTech Auto. So that means the concept of recall and review of its own judgment by NCLAT has now reached finality, and this because the Supreme Court has upheld this view of the larger bench of 5 members, where this entire procedure was defined. So now what we can say, that the NCLAT does not have power to review its own judgments. NCLAT has the power to recall its own judgments, and under what circumstances the judgments can be recalled: when any procedural error is committed in delivering the earlier judgment. And examples are also given, that the necessary party has not been served, or necessary party was not before the tribunal when judgment was delivered adverse to that party. So this is the kind of conclusion in this judgment. Going further, I would take up this RPS Infrastructure Limited versus Mukul Kumar and others, again a Supreme Court judgment. In this case, it is held that the new credit claims cannot be admitted when resolution plan is approved by the Committee of Creditors and is pending before the adjudicating authority. And is there any question, Ankit? Because this is a judgment again which is confirming the overall structure of the claim, so this particular judgment will also reduce a lot of litigation. If there is a question, otherwise I'll continue with this judgment.
No, you should continue. We will take questions maybe after this judgment.
So in this case, the RPS Infrastructure and KST Infrastructure Private Limited, which is the corporate debtor, they had entered into a development of land agreement, because this is a builder case. Some dispute had arisen, and the arbitration proceedings initiated, and an award was passed in favor of the RPS Infrastructure. While the as against the arbitration award, an appeal was filed and that appeal was pending. And during the pendency of the appeal, this KST infrastructure, in fact, was admitted to insolvency. So, since the appeal was pending, since the appeal against the arbitration was pending, therefore, probably RPS infrastructure did not file its claim. However, maybe since the appeal was either getting delayed or the appeal was also in favor of the RPS, so the then RPS filed a claim, and that was delayed by 289 days from the commencement of CIRP. Now, at the time when the claim was filed, the resolution plan was approved and it was pending before the approval. It was pending before NCLT for approval. So the RP rejected the claim. RP rejected the claim of RPS infrastructure. Now the RPS filed the RPS infrastructure. In fact, the first application was filed by RPS before NCLT, and NCLT said that since the RP should have seen the books of account, RP should have taken the claim, and RP should have seen the financial position and all this, and the public announcement may have been missed by RPS infrastructure. Therefore, the RP was directed to take the claim of RPS infrastructure. Immediately, the appeal was filed before NCLT, and NCLT NCLT reversed the judgment of adjudicating authority and held, one, that the public announcement is considered to be a proper service. Then, in this case, the RP had also filed an application under Section 19 that the various records are not given. Then IBBI regulations cannot be directory depending upon facts of each case. The new claims entertained the resolution plan approved by the LCC. In case the new claims are entertained, the resolution plan which is already approved will be totally jeopardized. Now, against this, the RPS infrastructure went to the Supreme Court. Now, the Honorable Supreme Court, in fact, held many good things and rather reiterated many good things in this case. As I said, that most of the claims issues are getting settled day by day. So the Supreme Court observed that there was no fault on the part of the respondent, means the RP. There was no default. There was no fault on the part of the RP. RP did what could be done to procure the corporate debtors record by moving an application under Section 19. The Supreme Court further observed that the public announcement would constitute deemed knowledge on the part of the appellant. The appellate authority has not approved the plan. It does not mean that the plan can go back and forth. So there are basically, in one judgment, there are many things that the Honorable Supreme Court has said. One, that if the records are not available, Section 19 application, Section 19 subsection 2 application is pending. RP has done whatever he is required to do, whatever he can do under the regulations and under the law. Public announcement, if somebody has not seen, that will not be considered as a ground for filing an application. Now, if the further argument was that the resolution plan has not been approved. No, it doesn't mean. The Supreme Court says that if the resolution plan is not approved, it does not mean that the application can go back and forth. So these many things have been actually, it's very important that we should see these many things have been decided in this case. Now, further, the Supreme Court says that Section 15 of the IBC and Regulation 6 of IBBI regulation mandate a public announcement of the CIRP through newspapers. This would constitute deemed knowledge to the appellant. In any case, their plea of not being aware of the newspaper pronouncement is not one which should be available to a commercial party. Now, the other party, the mere fact that the adjudicating authority has yet not approved the plan does not imply that the plan can go back and forth, thereby making the CIRP an endless process. This would result in reopening of the whole issue, particularly as there may be other similar persons who may jump into bandwagon as described above in the Essar Steel, the court cautioned against allowing claims after resolution plan has been accepted by the COC. We have thus come to the conclusion that NCLAT's impugned judgment cannot be faulted to reopen the chapter at the behest of the applicant. We find it difficult to unleash the hydra-headed monster of undecided claims on the resolution applicant. So this was the clarity given by the Honorable Supreme Court. Now, this another case is regarding the liquidator's right. This judgment is namely EVA Agro Feeds Private Limited versus Punjab National Bank. In this case, the issue which was decided by Honorable Supreme Court is merely because the liquidator has the discretion of carrying multiple auction. It does not imply that he would abandon or cancel a valid auction, fetching a reasonable price and opt for another round of auction with the expectations of a better price. The liquidator in this case issued a sale notice in June, and on 23rd of June, within say 21 days, the auction took place, and the aforesaid auction sale did not materialize. Thereafter, the liquidator issued a similar notice again after 5 days, and the auction scheduled on 20th of July. And in this particular second effort, the appellant was the sole bidder. And on 16th of July, the appellant was the sole bidder. And when the appellant was sole bidder, and the earnest money was also deposited. The earnest money was also deposited, and on the last day of the submission, the bid was so. Some of the and also the 10 crores, which was equivalent to the reserve price as notified in the bid, was like the bid completed only on the reserve price. There was no further single bidder, no further bidding. So it was concluded, say, at 10 crores. And the appellant received an e-auction certificate from the liquidator certifying that he had won the auction. See, the very next day, the appellant received an email from the liquidator informing that the liquidator had cancelled the e-auction and fresh e-auction would be conducted for the subject property. Now, in this case, the NCLT and NCLT, what these decisions were, the appellant means the successful bidder, in fact, filed an application before the adjudicating authority under Section 60, and then the adjudicating authority, in fact, the adjudicating authority decided in favor of the bidder. The liquidator was directed that this particular auction should be honored, and the liquidator did accordingly. The liquidator, in fact, issued the sale certificate, and the entire process was done. Then one of the financial creditor, in fact, the Punjab National Bank, filed an appeal before the appellate tribunal, and the appellate tribunal against the order. Now, let us see the appellate tribunal. The appellate tribunal allowed the appeal and set aside the order of the adjudicating authority, and whatever steps were taken by the liquidator on the directions of the adjudicating authority, those were also supposed to be reversed, and a fresh process was supposed to be conducted. Therefore, the appellant went to the appeal before the Supreme Court. Now, in this case, the Supreme Court says the necessary corollary that follows therefrom is that there can be no absolute or unfettered discretion on the part of the liquidator to cancel an auction which is otherwise valid. As it is an administrative framework governed by rule of law, there can be no absolute or unfettered discretion of the liquidator. Further, upon a thorough analysis of all provisions concerning the liquidator, it is evident the liquidator is vested with a host of duties. The duties, functions, and powers to oversee the liquidation process, in which he is not to act in any adversarial manner while ensuring that the auction process is carried out in accordance with the law and to the benefit of all the stakeholders. Merely because the liquidator has the discretion of carrying out multiple auctions, it does not necessarily imply that he would abandon or cancel a valid auction, fetching a reasonable price and opt for another round of auction process with the expectation of a better price. The tribunal has rightly held that there were no objective material before the liquidator to cancel the auction process and to opt for another round of auction. So this is a very, in fact, very good judgment, because at times the stakeholders also say that the liquidator has done it hurriedly, or there was only one bidder, there was no second bidder. Now the Supreme Court has held, even if it is a one bidder, the reserve price, everything has been discussed with the stakeholders. There was no objection. The valuation was done. The process was conducted complete. So it is not a matter of a concern that there was only single bidder, or it is not a matter of concern that there can be a better expected price realization. So once the process is done, it has to be concluded. Maybe little less price or maybe little more price. Now we have the last Supreme Court judgment, which is the Industrial Development Bank of India versus Superintendent of Central Excise and Customs and others. So these kind of cases, in fact, there are many such cases even before. So Ankit, this is a similar cases that we have cases where it has been held that under the liquidation process, the secured creditors have an overriding charge on the assets of the company, and the Customs Act does not create a first charge on the assets overriding the charge in favor of the secured creditor. So this particular judgment was not under IBC, this was under the Companies Act, because the winding up proceedings in this particular case, Shri Vishnu Priya Industries Limited, was in winding up under the Companies Act. So the Customs Department, in fact, had some goods which were actually warehoused in the goods for the recovery of the custom duty. The custom duty was not paid, so the custom department wanted to sell this particular asset. The official liquidator challenged it and finally got success, and finally it was held that the official liquidator has all the powers to sell the assets of the company. The custom departments would not have any right to sell the assets of the company, even if the custom duty is not paid on these assets. Once the assets are imported, whether the imported and lands in India, the ownership of these assets belongs to the company. And since the company is in official winding up procedure, the control, custody, and right to sell these assets would lie with the official liquidator. This is a judgment similar to the judgment that we have seen in the in IBC also. So this is a further confirmation that the Customs Department would not have any right on the assets imported by the company, and the customs are not paid. So Ankit, already we have now 1 hour is completed. If we can take some questions, otherwise this will continue.
So there's a question from there's a question which says whether the arbitration is pending before the arbitrator, and after sale of going concern, if arbitration award is passed on High Court direction, whether liquidator can admit a claim. So this is so if the arbitrator has given a decree and the liquidator not the recruiter does not deem fit that that award needs to be appealed, then it would receive finality, and therefore it should be admitted. But if the liquidator is of the opinion that no, the arbitrator's award should be appealed against because that will be advantageous for the distribution to the stakeholders, then that should be the process. Do you think
Yes,
that?
I believe any kind of proceedings against the company where the company's liability is increasing, the liquidator should first of all try and file an appeal, may it be GST, may it be Provident Fund, may it be any kind of claim which is coming on the company. And in case it is not yet crystallized, I think the liquidator must file an appeal, because anything which is impacting the distribution the liquidator must see the finality of that claim. Then only the liquidator should consider distribution under Section 53. And similarly, I would also say regarding an arbitration award, the arbitration award, if it is against the company, it is the duty of the liquidator to protect the assets and also to limit the liabilities of the company. Therefore, the liquidator is supposed to file an appeal if it is guided by the legal consultants.
So, with respect to the rainbow paper judgment now, if somebody receives a claim from Gujarat Sales Tax Department and the Gujarat Sales Tax Department insists that it should be admitted as a secured liability towards the dues outstanding towards them, what should the RP do now based on the, I think, the recent judgment? I'm forgetting the name of the
I
judgment.
think we should say that the impact of the Rainbow Paper Private Limited judgment of Honorable Supreme Court has actually been diluted by another judgment in the name of Raman Ispat Private Limited, which is again a case supported by AAA Insolvency. In that case, in the case of Raman Ispat, the Supreme Court has taken an opportunity to dilute the judgment of Rainbow Paper and have clearly said that for the statutory authorities, there is a special clause in Section 53, and all those statutory liabilities, even whatever secured or unsecured, that would fall under that clause of Section 53, which is Clause E, and will not fall under Clause B, even if it is secured. So the Clause E would actually have the priority, which is a fifth priority. So therefore, the claims can be admitted, but that particular priority would be given, which is as finally held by the Honorable Supreme Court in the case of Raman Ispat Private Limited.
So another question, interesting one, is that, and it says that the arbitration award is passed and the arbitration award is against the CD. Now the COC, which is in charge of the CIRP process, is not willing to finance the cost of litigating further with respect to that arbitration award, but the original promoters are willing to fund that litigation cost. So, is there any possibility for the arbitration award to be challenged at the cost of the promoters during the CIP process?
No, I don't think see, first of all, if anything has to be taken from the promoters, that should be taken by way of an interim finance. And for interim finance, the uh, uh, Section 28 resolution is required to be passed by the Committee of Creditors. So RP does not have any power to take any loan from any other person. In case in case any lawyer is willing to do any job without any fee, that may be the prerogative of the RP to do a litigation without increasing the CIRP cost, because the lawyer has agreed to do this job without any fee or for a nominal fee. I think the best would be to let the lawyer agree that the lawyer will only charge, say, 5,000 rupees. Then that can be approved by the Committee of Creditors. And the Committee of Creditor, or alternatively, the Committee of Creditors should approve the interim finance, which will be given by the promoters with interest or without interest. So these are the two options.
So another thing that I would like to add is that there might be a possibility that the former promoters can continue litigation in their name rather than the company's name, and kind of maybe say that they are funding this arbitration appeal, and because maybe the distribution to them due to this arbitration award might be lesser. So if the arbitrator or if the courts permit the promoters to continue continue challenging the arbitration award in their own name, rather as ex erstwhile promoters of dash and dash CD, then again that can also be allowed.
So I believe the promoters are considered to be an aggrieved party in case there is any liability which is coming on the company and which is impacting their interest in the company. See, anyone can say that this liability will jeopardize their interest because they also have unsecured loan, they also have shares. And in case the liabilities of the company is lesser, then they might even get something in this insolvency process. So they can still file an appeal in their own name as they are the aggrieved party.
Right. Great. So I think I've taken as many questions as time permitted, but yes, we are short on time. So there are questions that are still coming, but I think it's already 12:08, so we should understand the limitation of time and close this session here. So I think a lot of judgments that we discussed today that have been the latest judgments in the process, and I think we'll see all the participants again next week. And thank you all once again for encouraging us by attending our webinars in such large numbers. We are thankful for you to attend the webinars.
Thank you, participants. Thank you, Ankit. Thanks a lot.